Hey everybody, welcome here. Thank you for coming. We are really grateful today to have Professor Jeff Powell here to talk about intelligent design and Inherit the Wind. As you all probably know, or I hope you know, the Drama Society is performing Inherit the Wind this weekend, starting tomorrow. Friday at 7 p.m., Saturday at 7 p.m., and Sunday at 2 p.m. In Branson Theater on East Campus, which is not the theater that we were in last year. So take a look on the web or the Duke Law Daily for directions. We are really pleased to have Professor Jeff Powell here. I know he needs no introduction. You all know him as a great constitutional scholar. And what you may or may not know is that he also has a PhD in Christian theological ethics. So we welcome him now to get the conversation started. Thank you, Professor Powell.
Thanks, Ann. Let me begin by thanking the Drama Society for this chance. I'm really online now. I am really pleased to be able to have a small part in what is a very exciting thing. Inherit the Wind, and I will talk a little bit about the play in a few minutes. Inherit the Wind is an exciting play. It's very, very powerful. And this is a neat thing that they're doing. And this is just a little bit of that and just a little addendum to it. The main feature is the play. Let me just also bring to your attention something very exciting. The Duke program in public law with our own Chris Schrader as director is in the midst of final arrangements to bring Eric Rothschild, who is a lawyer, a Duke grad, and who argued the recent Pennsylvania intelligent design case on a pro bono basis. And we're in the final throes of trying to get Mr. Rothschild here to give a talk at noon on March 30th. And that'll be very exciting and will be a nice sort of, bookend to what the Drama Society is doing. So be on the lookout for that. Okay, July 1925, the small town of Dayton, Tennessee. A huge event occurs in American cultural history, and it really is big. You all may not remember the O.J. trial, but it's on that kind of level. People are riveted by what's going on in Dayton, Tennessee, in what is a very small scale, or one would have thought, criminal prosecution for a crime that leads to a maximum of a $100 fine. And $100 is more than it is now, but it's even so. We're not talking about big stakes criminal activity. What it is a man named John Thomas Scopes, a public school teacher, is being prosecuted for what he admits he did, which is to teach evolution in the public schools. Now, there are complex legal issues here. The statute forbids, what the statute actually says is that no one may deny the teaching of the book of Genesis that humanity was created by God by teaching that humanity is descended from lower animals. And there's this complex statutory construction issue about how that's to play. And then, of course, there are the constitutional issues that to you and me leap to the forefront of our minds immediately, although that probably wasn't for many people quite the front line of the issues. So you've got this prosecution of this guy for having, as indeed he always said he did, tell people that the present view of biologists is that humanity is descended from other and quote-unquote lower animals. This is a cause célèbre. It is a huge event. It's huge in a whole lot of ways. It's huge culturally in a variety of senses. The usual way to put its cultural significance, and this was the standard way of thinking about it in 1925 just as much as it has been since, was to see this as a kind of war between two segments of American society. Between the educated North and the ignorant South. between the sophisticated urbanites and the unsophisticated rural folks, between religious people and non-religious people. And there is truth in that. There was a regional overlay to this. There was certainly a religious side to this. There are all kinds of things you can say about it, and so there's some truth in this picture, which was a picture then and is a picture now. But it was much more complicated, much more complex. And in its complexities, I think we can see or get some, wake-up call to the fact that there may be complexities in our own situation that tend to escape us if we just buy the evening news kind of take on things. One complexity, at the time, major lobbying group fighting against the Butler Act. That was a state statute that Scopes was being prosecuted under. Major lobbying group against the Butler Act when it was in the state Senate was the consortium of Christian ministers of the city of Nashville, the state capital, who were arguing strongly that the bill ought not to be enacted into law. In fact, the Scopes trial laid bare a huge division within American Protestantism, not between people of religion and people of non-religion, but rather amongst people of not only religion, but of the same religion. Huge dispute. The mainstream Protestant denominations, who are at this point in time, clearly, they are where the power, social power in America is. The mainstream Protestant denominations, leaderships overwhelmingly, and memberships very substantially, are opposed to legislation like this. Believe it to be theologically erroneous, culturally embarrassing, evangelically disastrous. This is a fight, among other things, among American Protestant Christians. And it is furthermore a fight that divides people politically in all sorts of interesting ways. Two of the three huge figures, and I'm going to talk about them in just a second. Two of the three huge figures, William Jennings Bryan and Clarence Darrow, are old allies. Darrow's first intervention into public affairs was to run as a Democratic candidate underneath the bannerhead of William Jennings Bryan as a Democratic candidate for president, and they went together down to defeat. The Scopes trial lays bare a sharp division in what had been and looked like a very solid, if often losing, segment of American political opinion. And there too, I think we might well find some resonances with our own day as we look at this distant mirror. Okay, so this is a big cultural event. It's also a big event because there are three huge figures involved in the Scopes trial. And none of them are poor Mr. Scopes, who seems to have been a rather sweet nonentity. The major thing you can say about John Thomas Scopes was that he was willing to be the sitting duck, because this was a test case. This was made up. Nobody expected this to happen. Nobody wanted it to happen. When the governor signed the bill into law, he said, "This is not expected to be an active statute." Go think about that a little bit. In other words, we are doing as the Congress of the United States so often does, passing statutes in order to show how good we are, with no anticipation that anyone will do anything with them. They're just for show. Well, the organization that you and I know as the American Civil Liberties Union had a different view. And here's why they had a different view. And of course, it contradicts some of the usual kind of thoughts about the Scopes case. They thought, from their perspective, I'll just call them the ACLU. The ACLU thought that from its perspective, this was brand new, the first Butler Act type law was introduced into the Kentucky General Assembly like in 1921. So this is a new thing. Why, by the way, you're thinking it's a new thing? Darwin's, almost 100 years old by now. Answer probably has in part to do with the fact that public schooling has become so much more important. The percentage of Americans of secondary school age who are attending secondary school has gone from, in 1900, about 5% to by now about 40 to 45%. Huge jump. So it's, it's just a lot bigger thing. All right. So we've got the situation where people are paying attention and some big figures come in. Number one, William Jennings Bryan. 3 times the Democratic nominee for the presidency. 1896, 1900, 1908. Secretary of State during the first Wilson administration. One of the most beloved and one of the most hated figures in American public life. The great commoner, as he's often known, usually complimentarily, although I'm sure there were people who embraced the description and disliked the substance. Bryan is a great crusader, passionate about the causes he supports. Let me give you a few examples of the causes he supports. He has been a tireless advocate of women's suffrage. He has been a tireless opponent of child labor. He has been a fierce proponent of permitting the federal government to impose a graduated income tax and to impose significant constraints on big business. He is, in short, what a modern, TV newscaster would call a liberal. So there's Bryan. And Bryan comes in. Bryan is not a state attorney in Tennessee. It's a bizarre arrangement. He comes in and becomes the centerpiece, not actually the person doing the, carrying the water, but he's the centerpiece of the prosecution team. Because Bryan is a deeply and passionately religious Protestant Christian who thinks that the kind of teaching that evolution involves in his society is one which is hostile and demonstrably so to Bryan's religion. So there's one big figure. Second big figure. The ACLU, having recruited Scopes to deliberately do what will lead to the prosecution, and having, jabbed the prosecutors to make sure that they actually will bring the prosecution, which if they had been thinking carefully, they wouldn't have. The ACLU's got the lawyers on tap. It's got everything set up. And then walks in Clarence Darrow, the biggest criminal defense lawyer of his era. A figure, like criminal defense lawyers who are big cheeses tend to be nowadays as well, a figure alternately hated or loved by lots of people. In some ways, he's a lot like William Jennings Bryan. Darrow comes in, offers his services pro bono. I have read that this is the only time Clarence Darrow ever acted pro bono. Now, one of the results of having Darrow, this huge figure in there fighting William Jennings Bryan, this other huge figure, is that things tend to get out of control. Because, the prosecutors, who seem to have been actually very smart state lawyers, and the ACLU's people, who seem to have been very smart, ACLU-type lawyers, can't actually control the two principles, the real principles. Leave aside people like the judge and Scopes and, bit players of that sort. And that produces, for example, the problem that Darrow has his own axe to grind. As Bryan, no fool. The play is a little unfair to Bryan. The character, who is the Bryan character, is made to look, at times, somewhat like a fool. He was not. And Darrow never thought he was. Darrow totally understood. Darrow deliberately manipulated the procedures so as to eliminate summation speeches, because he did not want William Jennings Bryan to get the chance to give a summation speech. All right, so we got these two loose cannons, and then we have the third huge figure in the story, H.L. Mencken. Mencken was perhaps the most famous and unquestionably the most controversial journalist of his era. He was a man, this is the Devil's Dictionary kind of guy. The guy who has, opinions on everything. Of course, that makes him just like a law professor in today's world, but who has opinions on everything and is very happy to tell you. And is busy telling you. And he is, it may be that we have the three most hated and loved human beings in the United States of America in the same room throughout the 8 days of the Scopes trial. It must have been just stunning. Even now, when you read the transcript, I've never read a full transcript, but I've read an edited version of the transcript, it is really exciting. You're on the edge of your seat. When you read it along with things like Mencken's constant reports about how, Darrow is hammering the obscurantist, ignorant yokels, and, people on the other side saying that Bryan is, hammering the godless atheists. It's really great stuff. This was a show of a big sort. Okay, so we have this huge event, culturally very big. It kind of fizzles out. It's sort of sad. The penultimate day sees the actual confrontation. William Jennings Bryan goes on the stand. Yeah, I know, he's a lawyer for the state, but never mind. And is grilled by Clarence Darrow. The version in the play, I think, is a little unfair once again to Bryan, but it was exciting. It was big. And then the next day, the judge comes in and expunges the testimony. Can't be considered. Done with that. And it sort of fizzles out. The jury returns after 9 minutes of careful deliberation. The jury returns. Well, there wasn't anything to deliberate about. Scopes never denied that he had done the acts charged. The trial judge ruled that those acts were within the scope of the statute. What was the jury to talk about? Jury nullification. That's about all they could have done. And they didn't do it. All right. So the jury comes in, returns a verdict of guilty. The judge imposes a $100 fine. The case winds its way up through the Tennessee appellate system. And let's see, this is July of 25. In December of 26, the Tennessee Supreme Court holds that the indictment was sufficient, the verdict of guilty was within the facts presented to the trial court and the jury, and that the judgment had to be reversed because a Tennessee law said that fines above $50 could only be imposed by a jury, and that for technical reasons they could not reverse and send back down, have a jury impose it this time, so they had to throw it out. It was the perfect Solomonic decision. Tennessee has not done anything bad to Mr. Scopes and therefore embarrassed itself. And yet the honor and dignity of the state of Tennessee has been upheld, as well as its statute. All right. So that's, and I've left out one thing. Guess what happens 4 days after the trial closes? William Jennings Bryan drops dead. Now, this was interpreted by different people in different ways. There was one crowd that said, aha! And there was another crowd that said, oh ho! And you can supply the details without any difficulty. So nothing much, in one sense, comes of it. Fast forward 30 years. It's 1955. In December of 1954, Senator McCarthy, the great hammer of the communists, godless communists, mind you, of the godless communists, has been censured by the Senate. In retrospect, it's very clear that McCarthyism has been dealt a fatal blow, and that the kind of deep fear, genuine fear, of a sort that you and I do not have any experience of. It's hard to actually understand how people could have felt, but they did feel it, and they were not crazy to feel it. The deep fear of being caught up because of your political views in a kind of persecution, as it now looks to us from our perspective. That fear, in retrospect, maybe it's clear that wasn't going to come again, but that wasn't clear in 1955. And two people, Jerome Lawrence and Robert E. Lee, he did not come from Virginia. These two playwrights, very distinguished playwrights. One of them still alive, at least I think he is, Lawrence. And Lee only died in 94. Very distinguished playwrights. They collaborated on other plays as well. These two playwrights produce Inherit the Wind. And as they say in the introduction, the stage directions place the time of the play as not too long ago. And in the introduction they say, commenting on this, it might have been yesterday, it could be tomorrow. The play Inherit the Wind is about, no, strike that. The play Inherit the Wind reflects Lawrence and Lee's sense that the kind of struggle between free expression and governmental power, between the wishes of the majority and the rights of the minority, was not over in 1925, or rather 1926, when the Tennessee Supreme Court took off Scopes' $100 fine. It was not over when in 1954 the U.S. Senate censured Senator McCarthy, that this is a perennial issue in a free society, and that a play that was based on the events of the Scopes trial would be a powerful way of feeling and thinking and reflecting and living out those issues. And so that's what they set out to write. And in my judgment, and I'll be interested in yours if you have seen it or when you have seen it, in my judgment, it's a play that does that powerfully. That sets up for us a set of perennial themes. The relationship between faith and reason, the relationship between democracy and constitutional liberty, the relationship between grandstanding, and we had a series of grandstanders in the real Scopes trial, and that part is caught beautifully by the play, between grandstanding and serious public discussion. The play, I think, sets up those issues for us beautifully. Those are perennial issues, and therefore it's always timely to see or to watch or to stage Inherit the Wind. This is a particularly appropriate time, perhaps, precisely because we have some of the same issues coming up, or things that look, uncannily like the same issues. It was only yesterday, essentially, that the Pennsylvania District Court held that an effort by a local school board to insert intelligent design in some fashion, fairly mild fashion, mind you, into the public school curriculum was a violation of the First Amendment as well as of the Pennsylvania Constitution. So we're dealing today, and I suspect 100 years from now we will be dealing with these great issues. And the play is a way of stimulating, provoking, angering, and inspiring us to think about them. Having said that, let me stress something. The play is the thing. The play is what is itself. You make a mistake when you go to see a play looking for the real message, as if, for example, what I'm doing today is the real stuff, and the play is kind of, for those too feeble-minded to, take it straight, they have to have it with a dose of scotch and soda. No, the play is the thing, and your reaction to the play is the immediate thing you ought to, be reacting to, dealing with. The purpose or the value of something like today's little exercise is to give you some ancillary information that may help or inform or whatever your reaction to the play. Okay, Well, that was long-winded. I have more to say, but does anybody want to respond or say anything at this point? Stunned or asleep? All right. I want to talk about the Scopes case. We're leaving the play to one side now. I want to talk about the Scopes case and talk about the Kitzweiler, or however you say the name, case, the Pennsylvania case. I want to talk about three respects in which they are interestingly parallel and yet also dissimilar. One is constitutional law. There were constitutional issues that the Tennessee Supreme Court, and for that matter the trial court ab initio, took into account in the Scopes trial. If you go back and read the Tennessee Supreme Court's opinion, it is not a stupid opinion at all. The Tennessee Supreme Court says, in essence, we're going to take seriously what we've been told by the overwhelming majority of religious bodies that have spoken to this, including, and no doubt most influentially, the Protestant mainstream religious bodies that would have loomed most large in the social vision of most American lawyers in the early 20th century. And what they have told us is that evolution is not a matter of creed or doctrine or liturgy. It is a matter on which Protestant Christians, and indeed Jews and Catholics, the Tennessee Supreme Court's already being politically correct to the extent available. People of all these different sects disagree. Some think evolution, well, yeah, whatever the scientists say, if they want to say that, fine. If they want to say something else tomorrow, fine. All the way over to folks who are saying what William Jennings Bryan is saying, that no, this teaching contradicts the teaching of the Bible, and that contradicts Protestant Christianity, and that means it's wrong. It's not true. But we, the Tennessee Supreme Court, say, the overwhelming view of religious folk appears to be that this is a matter that they disagree about. Therefore, when the state takes a stand on this matter, it is not taking sides between religious groups or against any religious group. It's taking a stand that some religious folk will like and others will dislike, and that will be true of non-religious folk as well. We don't see anything in this, says the state Supreme Court, that amounts to an establishment of religion. We would recognize an establishment of religion if we saw it. Furthermore, they don't spend much time on this, but furthermore, they take note of the fact that Mr. Scopes may talk about evolution and may teach its truth. I started saying in school and out of school, but no, he can't do it in school. But he can do it out of school all he wants. His freedom of speech is entirely untrammeled. All that the government is doing is saying that when you take our dollar, you have to spend it in the ways we request. And one of our requests is you don't spend it to teach something that we don't want you to teach. As if the government were to decide, we also don't want to fund teaching Latin. I personally might think that's stupid, but it's hard for me to think of a constitutional objection to the government deciding, we just don't have enough money to spend on that. So the Tennessee Supreme Court's opinion, which I commend to you, is not at all a stupid opinion. Way fast forward to now. Because the Tennessee Supreme Court was not working with the benefit of the past 80 years of U.S. Supreme Court worrying, as well as a lot of other folks, about freedom of speech and freedom of religion and establishments of religion. So it didn't have all this vast body of case law to deal with. Well, nowadays, if you go and read the Pennsylvania trial court's decision, one of the things you will find is we have too much case law. I mean, the poor Tennessee trial judge, who seems to be a very smart lawyer, feels himself obliged to actually apply two he tries to make them fit together somehow, but in the end, they're just two separate lines of analysis without judging between them. Because as far as he can tell, the Third Circuit, within which he sits, does that. If it has an Establishment Clause issue, it goes through the endorsement approach of Justice O'Connor, and it goes through the Lemon test, always hated, always feared, and never killed, that dates from the early Burger Court. And he does both things. And his opinion goes on forever, and he actually at one point says, I'm so sorry this is taking so long. Clearly not a law professor. We got too much case law, and we don't know what to do with it. And it's kind of a mess. And it's interesting that it's such a mess, given the fact that these are such important issues and concerns, and that we have so little kind of agreement on how to handle them. So the two cases reflect the virtues and deficits of lots of case law. In some ways, the Tennessee Supreme Court was able to write a cleaner opinion because it didn't have to worry with so much. All right. Second thing I want to talk about and compare these two cases. Cultural context. The world is very different in some ways than it was in 1925. Although I have labored to assure you that it's too simplistic to talk about the Scopes trial as being North versus South, or urban versus rural, or religious versus non-religious, it is the case that the driving, passionate force behind the Butler Act was one that was largely driven by a fairly discrete and insular group in American society, American fundamentalist Protestantism. Now, those of you who are not American evangelical Protestants may, or even some of you are, but it's conceivable that you don't have straight the difference between fundamentalism and evangelical Protestantism. Fundamentalism is a subset of evangelical Protestantism. And one of the things going on with things like the Butler Act was that fundamentalist Protestants, perceiving themselves to be very much a national minority, very much besieged, very lacking in the ability to influence the way that society is going, were striking back, fighting back against a sense of siege. And, enlisting allies along the way. Brian actually wasn't a fundamentalist, but enlisting allies along the way in something that you can feel if you read the newspaper accounts. And there are lots of ways to get at this stuff, by the way. It's not, you don't have to go doing archival research. You get the sense of palpable, frustration and almost desperation that, the world that we believe is the true and real world is slipping away, and we need to fight to defend it. We need to fight where we can win the local battles, because we're not winning things on the big, scene. The General Convention of the Episcopal Church is not going to go along with us, or whatever. Now, contrast that with today. It seems to me there's both a contrast and a parallel. The folks who are behind intelligent design, for example, and I'm neither endorsing nor disagreeing. You can attempt to sand-trap me into telling you what I think, but only in a minute. The folks behind things like the Pennsylvania School District's decision are folks who do indeed show some of the same kind of sense of cultural angst, of feeling that this is a culture that has been hijacked by people they disagree with for goals that they disapprove of, using their tax dollars to do it. Something that, when I think that, whether I think that about this or not is another matter, when I think that about the government, I get unhappy with the government, as indeed That's my democratic and your democratic prerogative to do so. To be unhappy when the government is used to pursue goals that we disapprove of. So there's a similarity, and yet there's a huge difference because, well, just think about location. The Scopes trial was held in the Confederacy. The recent intelligent design trial was held in one of the keystones of the Union. We're not dealing with matters that are ripping us apart along sectional lines or along urban versus rural lines so much as we're dealing with issues that divide us all over the place as a polity, as a republic. And that's big and important and different somewhat, I think. The other point I wanted to make. I don't care for these purposes whether you like women's suffrage, getting rid of child labor, cracking down on big business or not. I have a view, you have your view, that's not the issue. Those are clearly what the Evening News would call liberal positions. Bryan is by our standards a liberal. Darrow is by our standards a liberal. One of the things that the Scopes trial lays bare is a process that is only just beginning and may not have ended, and the story is not over in any event, which is the breaking apart of different kinds of causes and inclinations, political and cultural and societal, which circa 1900 would have seemed to belong together. Bryan, the great commoner, the fighter for women's right to vote, and the fighter for evangelical Protestant values, that seemed like a whole circa 1900 to most folks, whether you liked it or not. You might dislike it, but it wouldn't have seemed like it was schizophrenic. For a lot of people in our society today, this combination of values would seem schizophrenic, like there's some, the person doesn't quite understand what she's saying. All right, so there's huge cultural things that are interesting here. All right, final thing, and I'm done. Theological. There's a big set of theological and religious issues going on in the Scopes trial and going on in the intelligent design dispute of our present day. And these are, and here the parallel is a parallel and not at all a contrast, these are disputes within religious communities as well as between religious folk, some religious folk, and other people, religious or not. They are disputes about how to understand the relationship between science and the claims of faith, between reason and those assertions that accept that they go beyond reason. These are very, very deep matters. We won't resolve them as the United States of America because Western cultures never resolved them, and those have been working on them for 2,500 years. And yet, in another sense, we have to figure out a way to live together as a polity. And one of the things that the Scopes trial and the intelligent design dispute right today make me think is that we have a big unresolved question. What do we do about the fact that some of our fellow citizens are passionately, irrevocably, and unchangeably committed to positions that you and I disagree with? And flip it around in your head to any which way. We can't ask our religious fellow citizens, or for that matter, our irreligious fellow citizens. We cannot ask them to check their convictions on these matters at the door as a price for admission into the public sphere. If the Article 6 religious test provision means anything, it means that. People can come into the public sphere, participate in the public sphere, fight for what they think right, and yet not surrender convictions that go beyond those of the public sphere. And yet, how do we make that work? Because those convictions, by definition, are not cabined in by that which we share. It is a huge question. We do not have a clear answer. It is one of the things I most love about the American Republic and about its constitutional law, that it represents an attempt to figure out a way to do it, even if the attempt has not yet been fully successful. Thanks. Did you want to, does anybody want to ask a question or, make a counter statement? Yes, sir.
I have a quick constitutional thing. What year did the First Amendment apply to the states through the 14th? When did that?
25 or 26?
Okay, so it would have been like right.
Right at this very time. And it's just the free speech and press guarantees. They don't get around to the religion clauses until the 40s.
Okay.
Or into the 30s. Well, thank you.
Thanks for coming, everybody.
Thanks. I hope that did not disappoint you.
I hope you